Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goewey, and I'm joined today by David Thompson here at Thomas Fisher and Edwards in Greenville, South Carolina. David, thanks for joining us again today. I'm looking forward to talking to you about another exciting topic here today.
Yes, excited to be here. Look forward to chatting.
And so, David, what we're going to talk about today is what we typically refer to in our practice as dynasty planning, but really all we're talking about is trust planning after someone has passed away, and often what will turn into multi-generational trust planning. But before we get too far in the weeds with that, do you want to maybe touch on some of the basics of what we're talking about when we're talking about trust planning and some of the basic benefits that come with trust planning?
Yeah, I'm happy to jump in on that. So a lot of times when we have an estate planning client that comes in and wants to meet with us to talk about their estate planning, the first thing that I get especially if they're like a first-time estate planning client and maybe have never engaged in the process, is that they want it to be simple. They'll come in and say, I want this to be simple. And there's a lot of pros and cons, and simple may mean a lot of things depending on how you're setting it up. But when a client generally comes in and wants something simple, what they're thinking, and let's just think in the context of leaving assets to children, they're thinking, well, when I pass away, all of my things I'm just going to leave to my kids, and maybe it's equally or not. That's not really relevant, but we'll leave it to our kids equally. Generally speaking, once we're able to educate clients, we may be able to modify that general thought against simple planning in favor of maybe creating what we would call lifetime trusts for the children. Okay, in that example, there are a variety of reasons, and we can dive into that a little bit more, Jordan. But that is the kind of the paradigm shift for most clients, is navigating from simple to, hey, we can achieve these other benefits with lifetime trust planning.
Yeah, and that's consistent with the conversations that I have with my clients as well. And so let's start with, if we just take what I would say that on average is our most common sort of clientele, it's usually going to be a husband and wife. Maybe it's a first marriage, maybe it's not. But regardless, it's usually going to be a husband and wife and then some children that they have. And most clients are going to want their assets to pass to their spouse and then pass to their children in some manner. And as you mentioned, often it's going to be some sort of equal split among the children, assuming that it's all children from the same marriage. So if we just take that basic scenario, let's start with planning for the children. And let's say that the client initially thinks that what they want to do is just leave assets outright to their children equally. How do you talk with those clients about the possibilities of perhaps improving that plan by incorporating trust planning?
Yeah, there's a couple of factors. I think the first place I start with is generally some form of a creditor protection discussion. One of a key benefit, I'll say, not the main, but a key benefit that we can obtain with proper lifetime trust planning for the children that are, trusts that are established by their parents, right, is some forms of creditor protection. There are kind of generally three types of creditors when you're thinking about it. There are accident creditors. You cause an accident and you have insufficient insurance. You could be personally liable for your negligence. That's one type of creditor. It's probably the least common type of creditor, but it is out there and it is a risk. A secondary type of creditor would be a financial creditor. That would be someone that, the individual owes money to, whether that be, they have their own business and they have personally guaranteed debt, or maybe it's, less savory forms of financial debt, like, credit card debt or something like that. But again, those are things that the person could be personally liable for. And those are probably more common than an accident creditor. And then the third and final creditor, and probably the most common by far, is what a marital creditor. So with clients, we generally start there, and the key for a lot of them is if we leave their assets, and let's say it's $1 million that we're going to leave to one child in a trust. Well, the benefit of proper planning is that we can potentially make it much more difficult for any of those types of creditors to access those funds, depending to some extent on where the beneficiary lives, and there are some differences across the states. But we can add a lot of benefit there to make sure that the money and the benefit that they are receiving from their parents stays with that child and subsequently stays with their descendants, if that is the goal of the clients, which for many of them that is. They want to keep assets lineally to pass down to their children and further descendants. So that's normally where I start with that conversation. I will say kind of the secondary piece of that, and depending on the size of the client, another primary consideration may be estate tax motivation, right? Properly designed, we can keep these assets that the child is receiving in trust outside of that child's estate for estate tax purposes. Now you can build, one of the other features of these types of trusts is we can actually build quite a bit of flexibility for that child inside the plan, right? It isn't a traditional type of trust where you're thinking that you've got to go to some kind of bank and ask some institutional trustee for money, right? That we could design that, and we have some of those out there, but primarily we have more of a flexible structure that allows the child beneficiary in this example to be their own trustee, right? At a certain age. At that time, they would be responsible for the investment management of the assets that are in trust. And they also have discretionary distribution authority subject to what we call an ascertainable standard, which the one that we traditionally use would be health, support, maintenance, and education. But there are other forms and flavors of those. But in addition to that, we can provide all manners of customization. I've had clients that want to do a unit trust and provide for like a stated percentage. I've had clients that want to say, yeah, we'll let them have discretionary distribution authority for up to 5% of the trust, right? Like they can only put out 5% in any given year. So it's immensely customizable, when properly done, and can provide for lots of flexibility. One further point I'll make is that we generally will give the child or the beneficiary what we would call a limited testamentary power of appointment. Colloquially, I would call it a shuffle power. And what that allows the child to do is, in their own planning, they can modify their plan with respect to the trust that they receive from their parents within a class of people that the original grantor, the parents, chose. So for most of our clients, that would be within their descendants. And where that could get used is if the child has further descendants that are born long after the original clients are deceased, they could modify the plan to properly account for differences. Maybe it's disparities in wealth between their children. Maybe one doesn't need the money and another does. Or maybe it's just change of circumstances. Maybe one child has one grandchild in this case has one kind of compulsive behavior, and we need to make modifications to the trust that would otherwise exist for their benefit. Now, our general default with children and this kind of planning is that we will do, and Jordan mentioned it at the top, dynasty planning, where this is held in trust for as long as state law will allow it. And that varies in each state, but in South Carolina, if there's money and there's descendants, you're probably looking at a period between 90 to 110 years.
And so what I'm gathering from all that, and I think is what is consistent with what I talk to my clients about as well, is that this sort of planning is not reserved just for, let me take a step back. I think typically when you watch television shows or movies and you hear about someone having a trust, it seems like it's something that's reserved for individuals that the parents maybe don't trust them, or they don't want them to be able to have access to the assets or have flexibility over how to use the assets. But based on the description that you just gave, I think it's a very key point that this sort of planning is not reserved just for someone who is untrustworthy or who is bad with money, but there's actually benefit there, and you can actually give that beneficiary quite a bit of control over the assets while still getting the benefit of trust planning.
Yeah, I think that is exactly fair, a summary there, Jordan. And I think that, yes, especially with first-time clients, that's a major, kind of thing we have to educate them on, is that, properly used and properly designed, your lifetime trust for the children can be a boon and a benefit rather than just some kind of impediment to their access. Now, as the wealth grows, sometimes that spectrum shifts and the clients are concerned about, hey, maybe we don't want said beneficiary to have, too much control. And there's ways you can mitigate that. And, the key one being who is the trustee is probably the primary way to think about that. But yes, I think it's something that's very, we see it, and I think it can add a lot of value to lots of estates, taxable or otherwise.
Yeah, and I agree with all of that it can be very valuable. You noted the part about protection from marital assets. One question that I get a lot from clients is if we're setting up these trusts for our children's benefits, does that mean that we no longer have to encourage our children to get prenuptial agreements? Do you feel like a trust can effectively take the place of a prenuptial agreement?
Generally with my clients, I'm going to encourage, if we've got irrevocable trusts out there for a child or another descendant, I would encourage them to still obtain a prenuptial arrangement agreement that properly discloses those trusts that they are beneficiary of. If it's more of an expectancy, like if it's just part of your base estate planning documents, maybe not. I think that it can be something that is beneficial to still have that kind of belt and suspenders there to make it very clear that distributions from the trust, to the extent that we can, are made just to the beneficiary, are not transmuted or converted into marital assets, to the extent that's possible. So yes, I generally would encourage them to still get a prenuptial agreement, but at the same time, I have clients that say, I'm comfortable with, this trust it's clearly separate property that I inherited. If I'm not taking the stuff out, I feel like I have a case that this is non-marital. Now, I will mention that distinction varies drastically across the states. I know of some states that are more willing to pierce that kind of trust structure if the child is a trustee. But from my understanding is that the majority of states have not gone that far at this point. And South Carolina certainly is not one of those.
Yeah, that's a really good point. So, at the very least, it's a nice extra layer of protection that you have there with respect to a potential divorce or something like that. And that really applies to all of the creditor protection that you get from these trusts, because you and I are not creditor protection experts. We don't practice debtor creditor law. And so we can't guarantee that these trusts are completely bulletproof. But at the same time, it's a pretty healthy layer of protection that these children of our clients would not have otherwise if we didn't leave assets in trust. Let's take a step back and think about this at the spousal level. So I understand why it's important to leave assets to children and descendants in trust so that we're getting these various protections that you talked about. But if you've got a long-term married couple, why should they consider leaving assets in trust for each other rather than just leaving their assets outright?
That's a great question. And I think I like to start with the children because the risks seem more concrete to clients a lot of times, in that maybe they haven't even told me, but maybe they have some concern about an in-law, like a son-in-law or a daughter-in-law, right? And they want to make sure that those assets are protected for their child. But a lot of times in the context of a family, there's actually more risk at the client level from a perspective of how assets are diverted from the family. So take a basic client like we just talked. Let's say it's a first marriage where they're married. What in a dream world in South Carolina, what we would do is we would have roughly, half the assets in one spouse's trust and the other half in the other spouse's trust. And when one of the spouses passes, we would form similarly structured irrevocable trust for the benefit of the surviving spouse. And the context and all the benefits generally are going to be the same that we've already talked about for the children. But there's one other key risk that kind of exists at that client level that doesn't really generally exist at the child level, is that we've got remarriage risk. If I just leave all my assets out to my spouse, it's possible that they could get remarried. If they own those assets, they can leave those to any people. It could be another new spouse. It could be a boyfriend. It could be a girlfriend. It could be a charity, right? There's a lot of ways and people that could receive. So what we want to do, if to the extent possible, is we want to protect, at least to the extent we can, half or roughly half of the kind of marital estate, especially in long married clients, so that we can ensure that at least some portion of the assets pass to kind of the joint recipients of the plan, even if that surviving spouse greatly modifies their side of the plan at some point in the future. So I think in a lot of ways, they're actually more important in terms of making sure we benefit the initially intended beneficiaries.
And then, David, I'll add to that, you obviously have the risk that, if one spouse passes away, the other lives for another 20 years, then they could get remarried. They could decide to leave things to a new spouse. And that's understandable in a way if they do get remarried and they kind of have ties to that new spouse. But the other place where leaving assets in trust for the surviving spouse's benefit can help is with respect to potential incapacity or them getting taken advantage of in some way and leaving it to someone that maybe they didn't intend to leave assets to.
Agreed. And the one other piece on that is that the issues and risks are even more acute when we're talking about subsequent marriages of the existing clients, right? Where they have children from the previous marriages or other relationships. All those risks are much more amplified, and then the need for marital level trust, whether bypass or a marital trust, is very, very important at that point to have that conversation and understand what the choices and options are.
Well, David, this has been a great high-level discussion, I think, of the benefits of trust planning at both the spousal level and at the descendant level. And of course, the goal of this podcast is to give actionable advice to clients. And what I would suggest in this case is that the actionable advice is think through whether trust planning makes sense. Don't get caught up in the idea that trust planning is only for the ultra rich, because it's not always. All the concepts we've talked about today can apply to someone with a much more modest estate, and in some ways can be even more important because you want to make sure that you protect those assets even more for your spouse and your descendants when the estate is more modest. And then in addition to that, just thinking through the fact that just because it's in a trust does not mean that this is restricting or handcuffing the beneficiaries in some way. Yes, we have to put certain limits on the beneficiary's ability to use assets in order to get the benefits of trust planning, but there can still be a lot of flexibility with allowing a beneficiary to be their own trustee in some circumstances, or otherwise giving them power over the trust, so that you sort of get the best of both worlds with the beneficiary having flexibility, feeling like they're not too constrained, but getting protection that they would not have otherwise. Anything that you would like to add to that briefly?
No, I mean, I really think we've come full circle on it, and I think that ties it all well to get together very nicely. And I appreciate you for having me on.
Yeah, thanks, David, for joining us again, and I look forward to talking to you in future editions of the podcast.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.